So, we'll discuss question number 15, state and elucidate the law relating to improvements made by bona fide holders under defective titles. So, the very answer that we found to this question is under Section 51 Transfer of Property Act, and as it is provided, it lays down the law relating to improvement made by bona fide holders under defective title. So, regarding that, we will discuss the very provision when the transfer of immovable property makes any improvement on the property, believing in good faith that he is absolutely entitled thereto, and he is subsequently evicted by any person having better title. The transferee has a right to require the person causing eviction either to have the value of the improvement estimated and paid or secured to the transferee, and secondly, to sell his interest in the property to the transferee of the then market value thereof, irrespective of the value of such improvement. So, the very essential conditions required the person evicted must be a transferee. He must have made the improvements, and such improvements he made believing in good faith that he was absolutely entitled. So, the very transferee is de facto guardian of a minor, and regarding that, we would like to discuss leading cases such as Harilal versus Govardhan, a leading case decided by Bombay High Court. This section applies only to the case of a transfer is such as a passenger from a de facto guardian of a minor who believed that the guardian had absolutely the right to sell, as it was decided in this leading case, Harilal versus Govardhan by the Bombay High Court. And we'll go to the second important leading case, and that is Secretary of State versus Dugufa. And in that case, it was held that a trespasser is not a transferee and is not entitled to compensation for improvements, as it was decided in this leading case. And now we'll go to the third important leading case, that is Sadashiv versus Dakubai. It also decided by the Bombay High Court, where it was observed that there are no equities in favor of a person who is fraudulently in possession, as it was decided by the Bombay High Court in Sadashiv versus Dakubai by the Bombay High Court. And now we'll go to another important leading case, that is Raj Kishore versus Jan Singh, decided by the Allahabad High Court, where it was decided a person purchases from a Hindu widow knowing that she is in possession of the property as a Hindu widow, having only a life interest, cannot claim the value of the improvements made by him upon the property, as it was decided in this leading case, Raj Kishore versus Jan Singh by the Allahabad High Court. And now we'll go to Another important leading case, and that is Ram Linga versus Swamipa by the Madras High Court, where it was held that a person who plants trees and makes improvement on another's land knowing that he has no title to it cannot claim the value of the improvements. On the same principle, a lessee cannot claim compensation because the lessee knows that his lease is terminable and cannot possibly believe in good faith that he is absolutely entitled to the property. So also a mortgagee is also in the same position. He is not entitled to the benefit of this section, for he cannot believe himself to be absolutely entitled to the mortgage property, as it was decided in this very important leading case, Ram Linga versus Swamipa by the Madras High Court. And now we will discuss the very portion dealing good faith. And in connection to good faith, we will also discuss important leading cases such as Rani Iyer versus Narayan Swami decided by the Madras High Court. In order to entitle a person to claim under this section, he must show that when making the improvement, he believed in good faith that he was absolutely entitled to the land. It is not necessary that he should show that he took all possible steps to investigate title, as it was decided in this leading case, Rani Iyer versus Narayan Swami by the Madras High Court. And now we'll go to another important leading case, that is Agra Bank versus Vary, and it was a case of 1874 decided by the House of Lords, where it was held carelessness is not inconsistent with good faith. Still, he must prove that he entertained the belief, and if the circumstances were such as to excite suspicion, then the commission to inquiry may be evidence of want of good faith. On the other hand, an omission to investigate may be evidence, if not explained, of a design inconsistent with a bona fide title dealing to avoid knowledge of the title, as it was decided in this leading case, Agra Bank versus Vary in 1874 by the House of Lords. And now we'll go to another leading case relating to this section, that is Hari Lal versus Govardhan, and it was decided by the Bombay High Court, where it was observed it should, however, be noted that the absence of good faith cannot necessarily be inferred from the mere fact can be said to act in good faith, even though he may have been to some extent negligent, as it was decided in this leading case by the Bombay High Court. Similarly, a person who acts under a negligence is a matter to be determined according to the circumstances of each case. And now we'll go to another important leading case, and that is Santana Kumar Nadar versus Indian Bank Limited of a case of 1967, decided by our Supreme Court, where it was held that there is no question of the appellant believing that he was absolutely entitled to the property, because he knew that he was purchasing as a small portion of it, and that his vendors stood to lose the property unless they paid off the mortgage money on receipt of notice from the mortgagee, as it was decided by the apex court in 1967 in this leading case, Santana Kumar Nadar versus Indian Bank Limited. And now we'll go to another important leading case, R.S. Madanpa versus Chandrama, and it is a case of 1965, also decided by the Supreme Court. So, where it was observed that no man who, knowing fully well that he has no title to the property, spends money on improving it, can be permitted to deprive the original owner of his right to possession of the property except upon the payment for the improvements which were not affected with the consent of that person, as it was decided by the Supreme Court in this leading case, R.S. Madanappa versus Chandrama in 1965. Now we'll go to another important leading case relating to this section, Arjun Lal Gupta versus Mriganka Mohan Sur, and it was a case of 1975, also decided by the Supreme Court. So, as it was decided in this particular leading case, there is no good faith at the instance of the person who trespassed a land and ignored the notice sent to him by the owner of the land objecting his unauthorized improvement, where the owner did not stand by watching valuable constructions being put on his land, but sent notices objecting to the trespass as soon as he learnt of it. The trespasser is liable to be evicted, as it was decided by the Supreme Court in this important leading case, Arjun Lal Gupta versus Maraginka Mohan Sur in 1975 by the Supreme Court. So now we'll go to the very concept of nature of improvement, and regarding that improvement under this section must be one which raises the value of property permanently. Ordinary repair of a house is not an improvement. Similarly, spending a small sum of money every year in manuring or labeling of lands will not be regarded as improvement as it was decided in the leading case, Saudullah Mathur versus Sankara in 1915. And now we'll go to the very mode of compensation. So, regarding mode of compensation, it is by being paid the value of the improvement or by buying the property at the then market value, and the very compensation depend upon the valuation of improvement. So the transferee may on eviction be compensated in either of the two ways. First one by being paid the value of improvements, or secondly by buying the property at the then market value thereof, respective of the value of the improvement made by him. So the very option as to mode of compensation is that of person causing eviction. The compensation to be paid would depend upon the valuation of the improvements as on the date of the eviction. So, the very answer to this question that state and elucidate the law relating to improvements made by bona fide holders under defective titles as it is provided under section 51 of Transfer of Property Act. And regarding the very answers, we have discussed the essential conditions required for such improvements, and also the very transferee who is either of a de facto guardian of a minor, or when it is a trespasser, is not as a transferee. So also regarding fraudulent possession, so also in the case of a Hindu widow having only a life interest as transferee, so also in case of transfer as leasee, mortgagee. So how they are not entitled? So in that context we have also discussed good faith. So also the very nature of improvement and mode of compensation, and in relation to all these we have discussed almost 12 important leading cases decided either by the Madras High Court or Bombay or Allahabad High Court, and also by House of Lords, and also certain important leading cases decided by our Supreme Court in respect in the year 1967, so also in 1975. So, in this way, we have finished the answer to question number 15, which would be the most appropriate and correct answer to this question. State and elucidate the law relating to improvements made by bona fide holders under defective title. So, in our upcoming video, we'll discuss the rest two important questions that we have framed, question number 16 and 17. As question number 16, he who will have equity must do equity. Elucidate the doctrine in relation to Transfer of Property Act. And question number 17, what do you understand by the doctrine of privity of estate in relation to the law of lease? So that we'll discuss in our upcoming video.